will now be moving into our sixth and final session of the day, and this is on the importance of an independent and impartial prosecutor system. So we have with us today, all the way from the UK, Sir Max Hill KC, one of the UK's preeminent barristers. Sir Hill has been the lead counsel on many of the country's most high-profile cases and has also spent 5 years as the Director of Public Prosecutions, or DPP, the most senior non-political public prosecutor in England and Wales. Thank you, Sir Max, for carving out some time out of your day to join us, and welcome to our event today. He will be joined in conversation by Deshamanya Dr. Radhika Coomaraswamy, a renowned international lawyer and human rights advocate. Having held a variety of prominent positions, including serving as the United Nations Special Rapporteur on Violence Against Women and the Special Representative of the UN Secretary General for Children in Armed Conflict, she has also served as a chairperson of the Human Rights Commission. With a distinguished career dedicated to promoting human rights, gender equality, and social justice, Dr. Coomaraswamy has been instrumental in shaping global policies and advocating for the protection of vulnerable populations. Her extensive contributions to academia and international law have made her a respected figure in the field of human rights, and we are honored to have her here today. Welcome, Dr. Coomaraswamy. Over to you.
Thank you very much, and I feel quite lonely here by myself, but welcome, Sir Hill. Since the introduction has already been made about you, I think we can go straight to the discussion. So I thought we'd begin the discussion. A lot of technical issues were just discussed in the session before us. But I thought we would just get out of the technicalities for a moment and just talk about justice, whether it's for corruption or terrorism or whatever. And whether, the WIS Center in Switzerland is doing a lot of research on the brain and justice, and whether you feel this is an innate yearning of people, and that if they don't have it, there are repercussions of social unrest, frustration that eventually manifest themselves.
Well, thank you for the question, Dr. Coomaraswamy, and good afternoon. And may I start by saying I wish I was with you in the beautiful Galle Face, a place that my wife and I enjoyed staying 25 years ago when we spent a month of vacation in your beautiful country. And I dined there only 5 years ago when I was in Colombo to talk about terrorism and how to counter it. So I wish I was with you rather than in a rather grey Saturday in London. The question that you ask is sensible and universal. And I suspect that the newspapers on the streets of Colombo today are no different than the newspapers on the streets of London, because in essence, they are full of cries for justice by individuals or by groups or by entities who feel that life has dealt them a bad hand. And in the particularly difficult area of criminal justice, which I suppose has been the majority of my career, there are cries for justice from the disempowered individual on a literally daily basis. And so I think this is a good place to start our discussion. Justice isn't something that is imposed on society by those who look after us, or even by those whom we elect. It is the answer by elected representatives to the cry for justice, which I think comes up literally from the streets and from all facets of society. And without wanting to drive too quickly to individual examples, even in the 6 months since I stepped down as Director of Public Prosecutions, I could name a dozen really pressing examples of victims of crime, bereaved families, crying through the newspapers for more to be done in answering the gross injustice that's been visited upon them. And that's a criminal justice example. We could take many other examples. So I think, Doctor, the answer to that first question is yes, it is innate in us as humans in a sophisticated, we hope, liberal democratic society to require justice, and we look to those who have the ability to deliver it, to do it well and do it fast.
Thank you. When we take it to the level of the system, why should impunity be fought? I mean, one of the backdrops of the IMF governance program is that impunity should stop. And I was thinking of issues like deterrence, or history has shown that if there is prosecutions, recurrence is not difficult. Do you think at a systems level, if there is impunity, there are repercussions for the society?
Of course I do. And I think that when you see a justice gap, the noise that I've referred to, and which I don't complain about, by the way, becomes ever louder. There is a sense in England at the moment that for far too long, perhaps for 2 decades, there has been existing impunity for our National Post Office, who pursued criminal prosecutions, I should add private prosecutions, nothing to do with the Crown Prosecution Service, against literally thousands of their employees for instances of dishonesty, which it now turns out were not dishonesty at all, but were due to defects in the computer systems that the Post Office was using. We are in the midst now of a public inquiry, which will report next year, and we'll have to wait and see whether that long-standing impunity ultimately results in criminal prosecutions. Nothing to do with me, it's beyond my time. But I think that impunity, if it exists, is corrosive, frankly, on the whole of society, but it's certainly corrosive on the justice system. I think that within that overarching answer, of course, there are many directions that we could take. One way of dealing with impunity is to spend far more on deterrence and prevention of crime, as opposed to sanctions being imposed once crime is discovered. And there is a delicate balance there, isn't there, between doing more to ensure that crimes are suppressed before they happen. That's about effective policing, effective investigation, as well as, on a balanced basis, dealing with crime once it does happen. And I know, because I was fortunate to listen to the previous panel, or a large part of it, that you have in Sri Lanka the sort of backlog in your casework that we're also experiencing in London. And wouldn't it be good if we were able to prevent crime in the first place, because then the backlog itself wouldn't grow even further. Now, the way that you balance those two, between prevention of crime and pursuit of crime, needs to be sensitive, but it is all ensuring that we do not permit impunity for offensive behavior.
Thank you for that comprehensive answer. Now, where did this idea of independent, impartial judges come from within the Anglo-American system? In Sri Lanka, the Gamsabhavas in the Kandyan Kingdom, etc., did have the same sense of that. But what were the roots and origins of the notion of an independent judge and an impartial judge, and how did it emerge? Independent prosecutor, let's say, as well as judges.
Yes, so I'll try and answer in 2 stages. As far as judiciary, it's interesting. Come to London, go to Westminster Hall, 1,000 years old, sitting alongside the modern or comparatively modern House of Parliament. Westminster Hall, where our late Queen lay in state just over a year ago, that is the origin of the King's Bench division of the High Court on the Strand, a mile away today. Why? Because in the time of the Tudor kings, and in particular Henry VIII, the judges who administered justice on behalf of the king sat on a bench on either side of the throne that he occupied, when he was present in Westminster Hall. So the bench was literally a sitting place for a very small number of judges to deal with the petitions that otherwise the king would have to deal with. And 500 years ago, you would have seen lines of applicants or petitioners trying to get time in front of one of the king's bench of judges to settle disputes. And that essentially was, in my view, the origin of what 3 centuries later became a huge expansion into the justice system that we know now, with the construction of the Royal Courts of Justice in the 1880s and the Victorian system, which benefited, is that the right word to use, or was certainly delivered to other parts of the world as well during former colonial days, implemented true independence with the construction of royal courts away from the palaces of Westminster or wherever else. So you saw this embedded notion of a separation of powers, which I think is vital, perhaps, to the discussion we're having this afternoon. And at the same time as the construction of the Royal Courts of Justice, the role of Director of Public Prosecutions came into being. So part 2 of the answer, Doctor, is that since 1879, there has been a DPP in England and Wales. I was the 16th incumbent, and I gave way to the 17th director 6 months ago. And although there are many more steps to be taken, and I'll deal with that perhaps in answer to further questions, this notion of setting up arms of state which were interlocking but independent of each other also led to the institution of the office of DPP, which although not as old as the office of Attorney General, has sat in a separate place physically and a separate place constitutionally for almost 150 years now.
Thank you. Just before we get into more details about independence, the left-wing literature always says there's no such thing as independence, that it's all about politics. And it just depends who's on power. Do you really feel that judges and as well as prosecutors, that there is an autonomous zone where they are separate from politics and do actually try to get at the truth?
I do, and that's my honest answer after 4 decades of legal practice. And whilst I am not an expert in comparative analysis of legal systems elsewhere, speaking for my own jurisdiction, I would say there is a reason why our judges are not appointed by or scrutinized by parliamentary committee. There's a reason why, and I don't want to sound critical of the American system, but there's a reason why we are able to appoint to the Supreme Court without a confirmation hearing being conducted in front of politicians in a Senate committee. Because however effective that may be in the States, and that perhaps is the last thing I should say about the US system, the impression created by that sort of appointment model is of political superintendence over the judiciary. However true or untrue that is, that's the impression created. You would struggle, I would suggest, to create the same impression in relation to the British legal system. Although we are replete with letters patent, seals of office, appointments in the name of His Majesty, and although that also applies to the upper ranks of the bar with the award of King's Counsel, that is for show. I'm not saying it isn't meaningful, but it has nothing to do with the operation of the office. So a High Court judge, when he or she takes the bench any morning of the week, is absolutely in command of the business of the court. And he or she will expect that the advocates in front of them, let's say a prosecution advocate, using the power vested by statute in the Director of Public Prosecutions, will also be entirely independent of the executive and of the political arm of state. So That's not to say that it's perfect. So the other element of the answer to your question is, of course, any system operated by humans in which humans are appointed to grave and weighty offices is going to have problems depending upon the individuals who are appointed, and you have to have mechanisms for dealing with that. That's why there's a judicial misconduct office in London, which can deal with any level of the judiciary in the event of misconduct. That is why I, as DPP, ultimately could decide whether a prosecutor should remain in post or not. So you have to have mechanisms to deal with that. But I think that the principle of independence stands us in very good stead. And we should be able to say to anyone who's asking, we are confident that the people who have these heavy responsibilities discharge them independently and rigorously. And if we can't look a fellow citizen in the eye and say that, then I'd suggest perhaps there's something wrong, either truly wrong or something wrong in perception of how the system operates, and shouldn't that be improved?
In some societies like Sri Lanka, you have an attorney general who is chief counsel to the state, as well as the public prosecutor. Is that a wise decision? Is that a conflict of interest?
Well, I suppose the first thing to say is that is by no means unique. There are jurisdictions around the world where you will find that the power of chief prosecutor, or as many countries call it, DPP, also emanates from the office or even the person of the Attorney General. So if that's how it works in Sri Lanka, you are not alone. But I think that the primary function, surely, of an Attorney General, whether or not they have cabinet status in the government in question, is to be the principal law officer and legal advisor to the politicians who run the country in the name of the government. And unless we were to say that the Attorney General doesn't do that, and I suspect that we must all agree that that is a prime function of an Attorney General, then in that circumstance, it can be a conflict for that individual also to be chief prosecutor, at least to this extent. When you are chief prosecutor, and I was incredibly fortunate to hold that role in my country for 5 years, there are no limits, there can be no limits on those whom you are empowered to prosecute. And so in my time, and all of my predecessors would say the same, there were a number, thankfully quite small, but a number of elected politicians whom we prosecuted. And there are a very small number of those politicians who ended up serving time in jail rather than serving their constituents in Parliament, because they had been independently prosecuted and adjudicated by judge and jury to be guilty of crimes that they had committed. If the Attorney General held that responsibility as well, then at the very least, in my view, it would cause a perception of conflict when an Attorney General might have to decide, however well he or she might go through this process, might have to decide whether a member of his or her same party acting in Parliament should nonetheless be prosecuted. Put that another way, it's surely a heavy burden on a political officer to have to make decisions like that over those who serve alongside them in Parliament. Surely better for that to be separated. And I'll give an example of that in the Scottish legal system, which is, as you know, is very close to us, but slightly different in its construction. The Attorney General, the principal legal advisor to the Scottish government, did not play any part in the investigation into the former First Minister of Scotland. It was the Director of Public Prosecutions, they have a different title in Scotland, it's called the Crown Agent, who made that decision entirely separate from the Attorney General, because it was the Attorney's job to advise the government when this unprecedented event occurred, that there was an ongoing investigation into the First Minister. And in that sense, my suggestion is it was a benefit for the Attorney General not to be responsible for prosecution, so much greater a burden had she had to somehow juggle the two. Now, it's absolutely not for me to express any form of judgment, and I'm even shy of commenting on the legal system in Sri Lanka. But that's the answer to the question that I would give from my perspective as an independent prosecutor. And we can go on to demonstrate how independence works and how, notwithstanding independence, accountability still flows through the office of DPP, and that accountability includes to Parliament, which is important.
So just how does a public prosecutor deal with issues of corruption? Because the IMF discussion which we're having here, a lot of it has to deal with issues of corruption. How would you go about it?
Well, I think let me give a lawyer's answer to this. In 2010, our Parliament enacted the Bribery Act. And because that was throwing a new veil over bribery and corruption, updating by a century the legal instruments that we'd used before, Parliament also decided that any case of bribery that was brought under the new Act should be the personal decision, the non-delegable consent of the DPP. So I found in November 2018 that I was personally responsible for deciding whether any individual should be charged with bribery or corruption. I have to say, after a decade of implementation, my view, expressed to a committee of both Houses of Parliament, was that although this was important and although the Crown Prosecution Service still needed to operate in this arena, in my view, I should be able, as director, to delegate to senior prosecutors the decision in individual cases. Actually, the Parliamentary Committee agreed with me, but time hasn't been found for the necessary secondary legislation to make that change. So the incumbent DPP still holds the consent personally. But the way it's done is by having specialist lawyers within quite complex structure of the Crown Prosecution Service, which I'm happy to try to describe to you, so that in a case where the Bribery Act is engaged, I did have the benefit of very detailed submission from an individual case team whom I could speak to, could question in order to make the decision. And I was very clear that as long as the relevant tests, what we call the evidential stage and the public interest stage under the Code for Crown Prosecutors, have been applied accurately, it was highly unlikely that my decision would differ from the direction of travel of the legal team. And that's a principle that I espoused actually in all of my work, remembering that in 99% of all of the cases brought for all crimes across England and Wales every year, my authority, although vested in me by Parliament, was delegated to Crown prosecutors at all other levels. And so I operated with a system of great trust in individual prosecutors to get it right, because they were independent, they'd been appropriately trained, they had experience in specific areas. And I was very rarely disappointed in that. And I think we could talk more about corruption. I think there's an issue in England and Wales about corruption in public office. That is something which is dealt with on a very historic statutory basis. At the moment, we have a Prevention of Corruption Act from 1906, which still applies in some respects. I think there's room there for the legislators to do more. But generally speaking, putting public office to one side, in the private sphere, bribery and corruption is adequately dealt with. And I think the floodgates that probably Parliament feared opening in 2010, which is why they imposed a filter invested personally in the DPP, hasn't borne out. Of course, there are cases, but it hasn't become a flood. it remains a trickle, but one that is looked at extremely carefully.
So, in high-profile cases which involve leading political figures or big corporate lobbies, in your lifetime, was there an attempt to interfere with these prosecutions? And how do you deal with those kinds of issues?
I think two parts to that answer. If you're talking about high-profile figures, obviously we could mean high-profile in industry, high-profile in politics, but let's take the latter. At the Crown Prosecution Service, we had what we sort of euphemistically called the Whitehall Protocol. And that meant that any suggestion that there was a need to investigate someone holding political office would be a London investigation, because that's where politics is situated. That would mean it would be the Metropolitan Police as to one of the 42 regional police forces for whom we're also responsible. And so we had a protocol between what we call the Special Crime Division of the CPS, experienced prosecutors, and the relevant unit, anti-corruption, the titles change, within the Metropolitan Police. So that would form a closed corridor for the transmission of legal advice from the specialist prosecutors and the transmission of evidence and material and investigative product from specialist investigators. And to my knowledge, that corridor was never punctured. And actually, it'd be very hard to puncture it. We can, if we need, operate on secure data systems, both at the police end and at the prosecution end. And we make sure that this casework is ring-fenced. And that means that a general prosecutor in a general crime team, whether in London or around the country, would not have access to the files that are being locked down within the special crime team who are operating the Whitehall Protocol. So we would keep that very, very tight. Does that mean that there were no attempts to interfere? No, it doesn't. And actually, an example which has been in the newspapers in London this week, therefore I can give it to you, of an attempted interference was intimated by the former Lord Chancellor, Sir Robert Buckland, who let it be known a few days ago that a member of Parliament had approached him with a view to complaints about the trial that her husband, then a sitting MP, was about to undertake. And there are political reasons, I think, why this story has come out this week, because the lady MP in question has defected from one party to another. But the point I'm making is that at a political level, that is a nugget of evidence telling you that there was what most of us would call an improper approach to, as it happened, the Lord Chancellor. Lord Chancellor dealt with it appropriately by saying, I don't make decisions about prosecutions. This is not on my watch. There's nothing that I can or should do about it. And I can tell you that he never came to meet. I was unaware of that sort of approach. That's another fundamental point, isn't it, about separation of powers, though, because the Lord Chancellor, a very senior minister, sitting in the cabinet, responsible for the court system, the judiciary, the prisons and probation systems across the country, superintending as Secretary of State the Ministry of Justice. But even though my office was in the same physical building as his, a literal separation between the two of us. And I can tell you that at no time did he or any of the other Lord Chancellors that I knew attempt to interfere improperly in casework decisions. I think that there's another layer of detail that will come into this if we're talking about the relationship between the Attorney General and the DPP. And I'd like to come on to that, but perhaps I'll pause and follow you, Doctor, in the direction we take.
Does prosecutors, can also go completely out of hand, as we know in the special prosecutors that have in the United States, for example. So what are the accountability mechanisms that for prosecutors that should be in place, in addition to giving them the full freedom to prosecute freely?
Well, the privilege that you have as a Crown prosecutor is that, in essence, you hold a warrant which comes from the DPP, the head of the service themselves, to make a decision on whether to charge a person with a crime or not to charge with that crime. That is a heavy responsibility. I have to say that I gave that responsibility to our thousands of prosecutors with high confidence throughout my time. But as indicated earlier, that doesn't mean to say that that function was discharged perfectly. And it is a fact that across my 5 years heading the CPS, we prosecuted a handful of prosecutors, and we didn't hesitate to do that. So there are former individual members of the Crown Prosecution Service who are also serving time in prison, whether alongside or in a different location to the handful of politicians whom we prosecuted. And that is, of course, essential to the public prosecutor's role to ensure that there is true accountability. And we applied the same standard of adherence to law and the rule of law to our prosecutors as society does to general citizens. So back to what you were saying about impunity, just because you're a prosecutor doesn't mean that the law doesn't apply to you. How do you go about that exercise in accountability? Well, that is down, in my view, to the sophistication of the model that you operate and the resources that you enjoy. Although I found a Crown Prosecution Service that was considerably depleted, the headline statistics are that in the 8 years before I became director, the national operating budget on an annual basis had been cut by 44%, and the headcount of the Crown Prosecution Service had been cut by 30%. And I spent my 5 years building that back up. However, even in times of austerity or comparative financial lucidity, depending on where you come in, you need to have a structure that ensures superintendence and supervision. And so a Crown Prosecution Service, any prosecution service, needs to be quite complex in the way that individuals are line managed and superintended. At a legal level, let me just quickly give you an example of how that operated. And what I use here is the example of what's called a sensitive case list. So in any system where you have hundreds or thousands of cases, there are the humdrum, the normal, the everyday, and then there are those cases which are either novel on a point of law, which involve application of new law, which bring with them notoriety, perhaps national press interest, that demand for justice where we started our conversation, and they will generally be sensitive cases. I operated a system where there was no case so sensitive that I would just step in and make all the decisions myself. Yes, there's a very small number of cases where I would hold the personal consent to make the charging decision. That's different. But just because a case was of such magnitude, complexity, or novelty, it wouldn't mean that I would step in. I would use, in essence, a triaging system coming up through the levels of the service to, in my case, directors of legal services, and I had 3 of them, who would sit down with me on a weekly basis and would inform me about the most sensitive cases. And that was an open channel of communication, allowing me to ask more about the case if I wanted, or simply to say that I'd noted it. The mantra behind this was, you, individual prosecutor, tell me about the case, tell me what your decision is, explain it to me so that I understand it, and I will support you. That's very different to, bring me a case that's difficult, I'll just make this decision for you. They're 2 different philosophies in how we make these decisions. Obviously, if in taking my approach of supporting decision makers, I found that their decisions were extremely poor, I'd have been in a difficult environment. But the ethos was, you're a dedicated prosecutor, you have the right training, you have the right line management, you know where to go for assistance in your decision making, and you have the trust from the very top to know that the decisions that you make, and they're very difficult and weighty decisions, will be supported. And I found that was a good ethos for running the National Prosecution Authority.
We have about 10 minutes left. Are there any questions from the floor? I can't see. Yes.
Case, could I just suggest that there's one thing I wanted to say. Forgive me. Is there a question coming in?
Go ahead, please.
The question back to the Attorney General and the role, single or hybrid, of an Attorney General making prosecution decisions as opposed to or alongside advising government. That's something that, although we have true separation of powers in England and Wales, is still important. And there's a key document, which is the framework agreement between the DPP and the Attorney General. It's available on the CPS website, which dictates how we operate around each other. It is signed by the Director and Attorney of the day whenever those offices change. And in essence, it gives an opportunity for you as DPP to share casework information with the attorney, but only on the basis of a need to know for those cases or those examples where, in speaking for the Crown Prosecution Service in Parliament, which the attorney does, because the DPP is not a member of Parliament, they can speak truth and they can provide a good service to those asking questions. Let me explain that in a slightly different way. There would be no instance of the DPP going to the Attorney General and asking what he or she thinks about a charging decision. But there would be many examples of us pursuing new lines of casework, novel application of new law, where we would want the Attorney General and her office to be informed, and we took that opportunity. So we were able to avoid disputes by having a robust framework agreement between the two of us. And for what it's worth, I commend that to you as an interesting way of taking a political officer alongside a legal officer and ensuring that they are both accountable ultimately to Parliament, but by delivering their roles separately without any actual conflict or perception of conflict with open justice.
Thank you for that very useful intervention. Mr. Butchers,
Yes. My question is to Sir Max. Can you explain to us how you source prosecutors in the UK? I believe that they are not full-time staff members, that you have the ability to source from the private bar.
Yes, thank you. I think so. The starting point for that is in many legal jurisdictions, particularly across Europe, the appointment of prosecutors is done by a council, a quasi-judicial council, who will consider applicants, interview them, and then appoint. That's not the way it works in England and Wales. I think it's a feature of the very different non-common law system that operates in most European jurisdictions, where there is a dual role of the prosecutor. Prosecutor is also investigator, and one thinks of examining magistrates in France, for example, where there's an investigatory power alongside a prosecutorial power. We're unburdened with that. We're prosecutors only, so we appoint our own staff, and it is a straightforward, open application system where we appoint the best from amongst the legal ranks to become prosecutors. But as your question correctly suggests, when it comes to the delivery of the hundreds of thousands of cases that we prosecute each year, we do not have the in-house resource to do that alone. The current split in advocacy terms is that 20% of casework is delivered through in-house advocacy, and that includes a cadre of several hundred Crown advocates, many barristers, but also some solicitors with rights of audience, whom we employ full-time and we deploy to the courts to prosecute our cases. But that's 20%. The other 80% is delivered by the external independent bar on a panel system. So as you say, it's not permanent employment. Application, which I think is fairly rigorous, to a series of panels. And we have general panels from entry level, panel 1, up to highest category, panel 4. And then there are specific panels, for example, for rape and serious sexual offences, for fraud offences, which experienced advocates can apply to join. So it's that hybrid relationship that allows us to drive all of the nationwide casework. I think if you look over the last 20 years, there have been directors who have been more aggressive and less aggressive about that. In the recent past, there are those who've said we should increase our in-house capacity to have more full-time employed prosecutors. And there are others like me who've maintained the status quo, although it's all subject to backlog and the flow of cases, which is very difficult at the moment. The only other thing I would add, though, is that I don't want us to overemphasize the advocacy of our cases. The division we have between in-house Crown advocates and external barristers is about advocacy. But when it comes to the administration of cases and the all-important decision to charge under delegated authority from the DPP to an individual prosecutor because of the Prosecution Offences Act 1985, that is a duty that is undertaken solely by fully employed in-house prosecutors. So it will always be an employee of the Crown Prosecution Service who determines whether a case is going to be charged. And I think that is important constitutionally, and from the point of view of superintendents, and from the point of view of sanction in the event that that is not done well. And we then, of course, have colossal administrative teams, case managers, paralegals, who run the material, run the case, but we rely on the external bar for the advocacy in the senior cases, and they do it extremely well.
Can I just ask a follow-up question? Do you have the same budget to pay, say, private bar members to be prosecutors as, say, the defender, or what is the intrinsic motivation to come and work on the prosecution side?
Yeah, well, very good question. And it's very topical because over my time as director, there was a gently swaying seesaw. At one moment, defense remuneration would be slightly up on prosecution, and at another, prosecution would be slightly up on defense. I came in 2018 determined to improve the rates of remuneration for the external bar under what we call our graduated fee scheme, which had been static for 20 years, as I knew, because I was a prosecutor myself externally before I joined the CPS as the director. And I went for money to central government and got it in 2019 for the first increase in the prosecution graduated fees in 2 decades. Not directly as a result of that, but one of the consequences is that the private bar ultimately went on strike in 2022 because they had not had an increase in the legal aid budget, the graduated fee scheme for defence advocacy, for many years either. And when that succeeded, that was not a strike against the CPS, it was the Ministry of Justice and the Lord Chancellor who were engaged in that, who were responsible for defence remuneration. That succeeded. Money was recovered from central government and the rates went up. And my immediate reaction was to require a second increase in the prosecution graduated fee scheme to introduce parity. So, the point of your question is it's got to be a level playing field. Otherwise, you will either lack prosecutors or you will lack defenders. Within the legal professions, we all know there's money to be made away from crime and criminal justice, and there's more money to be made. And it doesn't take much before people will start to specialize and move away. There needs to be a contract, a compact with the legal professions so that they recognize that remuneration is sufficient. It may not be the largesse that is available in private civil commercial practice, but is sufficient to maintain their duty, the part of their working lives in which I would say there is a duty to ensure the upholding of the rule of law by working in the publicly paid legal sector. And when it comes to that, there should be no distinction between what a prosecutor earns and someone defending. So when it came to the use of the self-employed bar, my mission was always to balance that seesaw and to keep the scales even. As I speak, they are pretty much even, and we'll have to see what happens in future.
Thank you. We have about a minute left. Is there a message you have for us in Sri Lanka? Now, you know, we would urge us toward a office of an independent prosecutor, or any other messages?
Well, I think perhaps, you know, it's worth all of us, whichever our legal system and wherever around the world, to pause and look around from time to time. There are legal systems that just differ dramatically from our own. And we, that's England and Sri Lanka, happen to be in the common law part of the legal world. So I think that we can draw useful comparisons with other jurisdictions who operate similar systems of laws, where that would be more difficult in another jurisdiction, even the United States, but certainly Europe. But when I think about Kenya, for example, not so far away, when I think about South Africa, when I think about my colleagues in other parts of the world who operate in a similar legal system, who have, I have to say, challenges beyond any that I've faced. Think of the state capture cases in South Africa. Where I see it being done best is by dedicated, decently resourced, truly independent public prosecutors who are not subject to political pressures from anywhere across the spectrum. And that needs to be a real state of being. And even if there is a perception that those who make decisions on whether a crime should be charged, even if there's a perception of a political motivation or political pressure on that decision, that is a perception that we need to avoid. And I was very keen throughout my time to ensure, through the maintenance of the framework agreement that I mentioned, that nobody could say that any decision I made was only made because the Attorney General wanted it so. And you could add other lines to that, because this person or that politician wanted it so. So I think if you are looking around the globe for examples of common law systems which have so much in common with yours, but where there are differences, that can only be a good thing, and can only deliver the challenge that the doctor gave us at the very start of this conversation, which is the fact, and I hope we all agree on this, that a sense of justice is innate in us as human beings, and a lack of justice, or an appearance of that, can be enough to destroy the whole perception of fairness, and things unravel if that's how people think. So I think valuable and valid opportunity to think about legal systems. And whilst I am the last person to tell you how you might make change, I hope at least it's been an interesting comparative exercise to see how I've been trying to do it in my country.
Thank you very much. And of course, in the end, it is public confidence that keeps our systems and institutions functioning. So thank you very much for a very rich and detailed and comprehensive answers to all my questions. I wish you well. I know you're in a hurry and you have to go to another meeting. Thank you for sparing the time to be with us. Thank you.
Thank you very much.